being mocked and abused by prison guards, being mistreated, assaulted, or forced to stand naked in a jail cell for 10 hours. These despicable actions are all things we probably associate with other countries, certainly not our own. But it might surprise you to know that all of these actions are not only happening in the United States, they often happen without repercussion or punishment of any kind. Although prisoners lose some rights when they go to prison, they certainly retain some federally secured rights, along with human dignity. Dignity which the current legal system refuses to protect. It's because Caleb and I believe that this must be changed. We stand resolved. The United States federal government should significantly reform its policies regarding convicted prisoners under federal jurisdiction. Now, before we get any further, we'd like to present a standard, or a weighing mechanism through which you can evaluate this matter. And that standard is justice. We simply want to reach a more just system through the passing of our plan. Now let's examine the terms that are central to today's case, and the idea you can write down as context, the terms. The first term is that of the Prison Litigation Reform Act. The Prison Litigation Reform Act, or PLRA, was passed by Congress in 1996, the goal being to weed out frivolous prisoner lawsuits. Though well-intentioned, this law created numerous hoops and needless red tape, which have stopped prisoners from having their day in court. The second term is that of frivolous litigation. A frivolous lawsuit is a case that is not based in fact or in law. The purpose is to make money or to waste time. For example, let's say certain prisoners don't like the food that they're served and decide to sue the prison. But in direct contrast to this, we have meritorious lawsuits. A meritorious lawsuit is a real lawsuit about a serious issue like a constitutional rights violation or abuse. Now, before we get into the problem, I'd like to start with one widely accepted legal principle. And you can write this down as right to access the court. Right to access the court. Attorney Samuel Riley explains in the Emory Law Journal in 2021 that in Bounds v. Smith, the court recognized that it is established beyond a doubt that prisoners have a fundamental right, or a constitutional right, to access the courts. Attorney Melissa Bonarofe further elaborates in October of 2021 when she says one of the most important rights recognized by the court was a prisoner's fundamental right of access to the courts in the first place. Federal courts acknowledge that an inmate's right of unfettered access to the court is as fundamental a right as any other. But unfortunately, this right is repeatedly violated, and you can see this in the problem we're trying to reform. You can write that problem down as red tape. Red tape. The red tape problem comes from a provision in the PLRA called the exhaustion provision. It requires that prisoners go through every single step of a prison internal administrative appeal process before being able to proceed to court. Federal courts under the PLRA are required to dismiss cases before it's even heard, if it hasn't checked every single box of a prison grievance process. This provision offers no standards, no time limits, and it allows each prison to create their own bureaucratic process. The red tape problem results in two distinct harms. Harm one, conflict of interest. According to the University of Baltimore Law Review, they noted in 2015 that under the current model, a prisoner must avail themselves to must submit the initial grievance to the same officials who created the procedural schemes and who are often named defendants in the underlying action. This reality creates an inherent conflict of interest in the current administrative remedies scheme. To illustrate the absurdity of this, consider Attorney Stephen Bright's account of an inmate who had 5 days to file a grievance after being beaten by a guard with a sock full of combination bullets. Because this inmate was in and out of consciousness during his filing period, he was unable to file the paperwork and his case was dismissed. This is absurd, but unfortunately it's not uncommon. Rules about tight deadlines, complicated paperwork requirements, and even ink color are all too prevalent. And the result, you see this in harm two. Suits blocked. According to attorney and judicial law clerk Ryan Lefkowitz in 2018, he said the exhaustion requirement applies to all types of prisoner lawsuits. It has been constantly and aggressively applied by the courts, blocking prisoners from ever going to trial. Attorney Melissa Bonarofe further explains in October of 2021 that thousands of prisoners' civil rights cases have been dismissed for failure to properly exhaust administrative remedies, without regards for the merit of the claim. So the impact of all of this, you can write down in 2 primary points. Impact 1, thousands of cases dismissed. And impact point 2 is access denied. The University Baltimore Law Review notes in 2015 that the single biggest obstacle in the way of vindicating constitutional rights is the Prison Litigation Reform Act, specifically the exhaustion requirement. Failure to adhere to even the slightest procedural requirement is sufficient to warrant a dismissal, regardless of the merits of the underlying claim. Prisoners have a fundamental right to access the courts, but unfortunately, because of the red tape and exhaustion provision, described as the biggest obstacle to constitutional rights, that has facilitated an outright denial of their rights in abusive situations. It's because of this that Caleb and I offer the following policy. Mandate. Immediately, Congress will pass and the President will sign Section 3 of the Prison Abuse Remedies Act of 2009. One amendment will be made to this bill, and it will only apply to convicted prisoners under federal jurisdiction. Section 3 of the Prison Abuse Remedies Act, otherwise known as PARA, amends the exhaustion provision by adding a time limit. A prisoner will be given up to 90 days after filing the lawsuit to resolve the claim within the prison system. The case will go to court 90 days after a lawsuit is filed and no resolution has been reached within the administrative remedy system. There are 3 primary advantages to this proposal. Advantage 1, rights restored. The Philadelphia Bar Association says that this amendment would ensure prisoners are afforded meaningful access to the judicial process to vindicate their constitutional and other legal rights. End quote. Advantage 2, accountability reestablished. Law professor and practicing attorney Stephen Bright testified before Congress on behalf of our policy, saying that under our policy, quote, prison officials would have an opportunity to resolve such complaints, but would not be able to dodge accountability with complex and technical requirements, end quote. And advantage 3 is frivolous litigation restraint. Our plan addresses the red tape problem by changing one of the provisions in the existing legislation, but it keeps the effective provisions in place. The negative team will probably get up here and it brings you a couple ridiculous cases about individuals with claims that legitimately should not be heard, that are about silly issues that may even sound a little bit humorous, but our policy addresses these. The Columbia University School of Law notes it like this. They say the PLRA requires federal courts to examine all suits filed by prisoners. The PLRA requires a court must dismiss a case that are frivolous or malicious, and the court must dismiss these claims as soon as it sees them. So as you hear some silly examples in today's debate round, I'd like you to keep in mind that our policy actually already addresses them. There is a problem in the current system. Thousands of prisoners are denied their access to court because of a broken bureaucratic system. By passing PARA, we restore constitutional rights to federal inmates. We reestablish accountability, and ultimately, we uphold justice.
How are you doing, Nathaniel?
I'm doing great. How are you?
I'm glad to hear that. I'm also doing well. Congratulations on making it to semifinals. I have a couple of questions. Starting off, would you agree you have the burden to prove a quantifiable harm in the current system and a quantitative advantage to pass?
We have to show that there's a harm in the current system and that our plan will solve that harm.
Would you agree you have to prove with statistics that the harm is present?
I don't necessarily believe that we have to prove with statistics. We have to show a significant harm, and significance is quantified for a number of different means.
Sure, so one of those means could be evidence, right?
So statistics can be a way to quantify a harm, but you can also look at the overarching impact of the policies in general. There are several different ways to quantify significance.
Okay, so talking about significance specifically, how many meritus cases have been denied because of the PLRA?
Yeah, so that's actually the entire problem with the PLRA, is that it doesn't allow the courts to evaluate the merits of the claims. And as such, that's an unreasonable number for us to achieve and something we can't provide you with.
Sure, so would you agree that your harm, the claim of your harm, is that meritus cases are being denied in the current system?
Right, so as I was continuing to say, the majority of these claims, as analyzed by attorneys and several different people, is that the majority of them raise serious issues. And so underneath our policy, the harm is that the merits are not being evaluated, but the reality is the majority of them are serious.
Sure. So if there's a majority, how many meritus cases are being denied because of the PLRA?
Again, I can't give you a specific number, but I can reference different evidence that we have.
Do you have any studies showing how many meritus cases?
Right, so again, you're asking for a number that is impossible to quantify. It literally cannot exist because it is the harm in the current system.
Okay. All right. So would you agree that citizens as well as prisoners must prove physical injury to have compensatory relief in a lawsuit?
To have monetary relief in a lawsuit, prisoners as well as individuals have to prove a physical harm.
prisoners as well as law-abiding citizens. Would
Yes.
you agree that under PARA, they removed this physical injury requirement in lawsuit in court?
Under the entire policy, yes. However, if you reference back to our mandate, we're only passing section 3, which is specifically the time limit on exhaustion.
And so how much are you extending that time limit for?
So we're actually creating a time limit because there's no standards in place currently, and that's a 90-day time limit on the filing of these lawsuits.
And what evidence do you have that shows that 90 days is sufficient time for these
We
prisoners?
have many
to
different advocates, actually. The Philadelphia Bar Association, the American Bar Association,
Sure.
several attorneys and also judges have advocated for this policy.
And do they talk specifically about 90 days? Or
Yes,
do they
about
advocate for
specifically
reform?
90 days.
Okay, if we could see that advocacy,
Absolutely.
that would be great. Now, can we agree that justice can be defined as equal protection under the law?
Sure.
Equal protection for citizens and prisoners alike?
I suppose we can say that.
And can we agree there's other forms of release besides compensatory or monetary relief in the current system that prisoners can have?
The problem is right now, a prisoner can't be heard in court because of the exhaustion requirement. So it doesn't matter what type of relief is technically available to them because their cases are never evaluated.
Okay, so can we agree that regardless of the exhaustion provision, they can still receive injunctive relief for their claims?
If their claims can be heard.
All right, thank you for your answers.
In the team policy debate round, whenever the affirmative team presents a policy that we're considering whether it should be passed or not, there is one main burden that the affirmative team has to prove in every single round. They have to prove that their plan will actually cause a significant net benefit over the current system. They don't just have to show that it could, they have to prove to you that it will. What I'd like to do in the first negative speech of today's round is go over all of the reasons why their plan will not be able to solve the harms that they presented in, that they say are in the current system. Just to clarify, I'm not going to be going over any of the disadvantages that their plan will bring along. Haley's going to be talking about those disadvantages in her first speech. What we're going to be focusing on is why their plan won't be effective. I'm going to do this in a couple of different ways. I'm going to have 3 main points, but before I do that, I'd like to bring up one main burden of proof for the affirmative team that they have to show if you're going to vote for them. You can simply write down this burden of proof as will have access to courts. Will have access to courts. Now, it might seem kind of silly to say that they have to prove that people will have access to courts if, as they're claiming, the thing that prevents these people from accessing the courts is removed. However, in order to see why they need to prove this, we can look to how the situation was before the PLRA was actually passed. You can write down this one card of evidence as didn't have access before PLRA. Didn't have access before PLRA. I'd like to read this card of evidence, which is from SF Gate, which is a newspaper which is now known as the San Francisco Chronicle. Back in when this was written in 1995, October 23rd, 1995, they went by a different name. But this card of evidence says, quote, studies showed that only 2% of prisoner lawsuits reach settlement and 1% go to trial. Joan Kavanaugh, who oversees a team of state attorneys who work exclusively on prisoner litigation, said inmates have no deterrent to filing lawsuits, unquote. This is before the PLRA, and yet only 3% of prisoner lawsuits ever reached any kind of settlement or any kind of resolution whatsoever. Still, without the PLRA, 97% of lawsuits did not reach any kind of resolution. The affirmative team has to prove that with their plan, even if we take away the exhaustion provision, they will have, inmates will have access to the courts because they didn't have access before the PLRA. Now, interestingly enough, the inmates actually have better access to the courts now than they did before the PLRA was passed, before the supposedly harmful bill was passed. That's because of one key reason. You can write down my first point about why the affirmative team's plan isn't needed and won't be effective as Ross v. Blake. Ross v. Blake. This is a Supreme Court decision by the U.S. Supreme Court that was decided in 2016. Now, this 2016 date is really important because because I went through the 1AC of the affirmative team, and it turns out that they only have 2 cards of evidence, or 2 sources that were written after 2016. A lot of their evidence is from 2015. Now these 2 sources, both of these sources, one is from 2021 and one is from 2018, neither of them actually say that the exhaustion provision being implemented is unjust. The first one merely says that the exhaustion provision being implemented has prevented prisoners from having their cases heard. Now, as we'll see later on in my second point, that fact alone doesn't mean unjust, or it doesn't mean that justice is lacking. The second source that they had, again, doesn't say anything about the exhaustion provision being implemented being unjust. So they need to show us evidence after 2016 that actually says that the exhaustion provision is unjust. The reason they need to show this is because Ross v. Blake fundamentally changed how the exhaustion provision is implemented and can be implemented in US law. I'm going to have several subpoints under this. The first one you can write down as unavailable remedies. Unavailable remedies. The affirmative team talked a lot about how there are essentially administrative remedies that these prisoners have to go through in order to have their cases heard before the courts, and they talked about how they can't really do this a lot of the time. However, Ross v. Blake changed that. I'd like to read this piece of evidence which comes from the Supreme Court's decision in Ross v. Blake, June 6, 2016, and it says, quote, under 1997, the exhaustion requirement hinges on the availability of administrative remedies. An inmate, that is, must exhaust available remedies, but need not exhaust unavailable ones. The decision goes on to say, quote, as we explained in Booth, the ordinary meaning of the word available is capable of use for the accomplishment of a purpose, and that which is accessible or may be obtained. Accordingly, an inmate is required to exhaust those, but only those, grievance procedures that are capable of use to obtain some relief for the action complained of. Unquote. So the only administrative remedies that inmates have to exhaust, according to the Supreme Court, are remedies that can lead to them getting the situation that they're complaining about fixed. That is it. The affirmative team has to prove that Ross v. Blake did not fix the current situation because, simply put, it did. Now, the Supreme Court went into more detail about exactly what it meant by unavailable and available tests. We have all of this information available for the affirmative team, and we'll be bringing it up in future speeches. However, I'd like to move on to my second point, which is dismissed without prejudice. You can simply write this down as dismissed without prejudice. Now, this is going to essentially act like another burden of proof for the affirmative team. What is being dismissed without prejudice? I'd like to read a card of evidence about this, and this comes from Alan Mazula and Eve Not Gaynor, January 27th, 2020, and it says, quote, failing to exhaust one's administrative remedies is a prevalent affirmative defense in prisoner civil rights litigation, primarily in dismissals without prejudice, unquote. Another article by Elizabeth B. Carpenter, who's a New Orleans criminal attorney, August 8th, 2016, says, quote, if the court finds that the prisoner has not exhausted, the case is dismissed without prejudice, meaning that the lawsuit may be filed again once the prisoner has exhausted, as long as the statute of limitations has not run, unquote. So they have to, again, prove that all of these cases that they're talking about getting dismissed or not being heard are being dismissed with prejudice, not dismissed without prejudice. If something is dismissed without prejudice, then because the prisoner failed to exhaust their administrative remedies, the prisoner can simply bring up the case again once they have finished exhausting these remedies. Again, only available remedies, not unavailable remedies. Ultimately, Ross v. Blake fixed the problem. Not only did it fix the problem supposedly in the current system, but it made the situation better than it was before the PLRA was implemented. Thank you.
I trust you're doing well today. I just have a couple did that card that you talked about on prisoners' lawsuits and the success rate of these lawsuits? When was that specifically from?
It was from October 23rd, 1995.
I can see that evidence. I can go ahead and pass that back to you.
Of course, yeah.
And then specifically, does that evidence mention whether it's a federal statistic or whether it's a state statistic?
The card of evidence didn't specify.
Okay. So it's perfectly likely that that could be in the states. We have no idea if it was federal or state, correct?
Again, didn't specify.
Okay. Great. Now you talked about exhaustion and how under Ross v. Blake, exhaustion is no longer a problem. Did you provide evidence towards the effect that people are using the exceptions or that they haven't been used ever?
I didn't have any specific evidence about that. Again, my evidence was from the Supreme Court case itself.
Can you give me any statistics on how often these exceptions, opposed to Ross versus Blake, are actually used in the legal world?
I didn't provide it.
Okay, but you haven't.
I can check back and forth.
That'd be great. Now, specifically underneath Ross versus Blake, can you agree with me that they ruled there is no special circumstances exception, only unavailability, correct?
Yes.
Okay. And so basically, the only thing that they can take into account is whether it is unavailable, correct?
Yes.
Okay. And what specifically does unavailability look like?
Yeah, so I read the definition that the Supreme Court used. There's also some more specific language that the court used, but essentially what the court said is that they are procedures that are capable of use to obtain some relief from the action.
Okay. If it's capable to obtain something, great. Has anybody done this?
Yeah.
Thank you. Now, the last thing we talked about was the idea of dismissal without prejudice, which is effectively that the prisoner can go back and exhaust and then come back to court. So let me just pose to you a couple of questions. Let's say a prisoner missed the filing period because, like our 1AC, he was unconscious. Can that prisoner actually ever fully exhaust his administrative remedies?
Well, as I would, looking at the specific language of Ross v. Blake, that would be considered an unavailable.
Okay, sure, but we're just talking about dismissal without prejudice. So specifically when it comes to this, if you miss a deadline, and let's say you go to the court, you're thrown out, and you go back, are you ever able to fully exhaust your administrative remedies?
Well, we would never see that situation again because of Ross v. Blake.
Okay, but you would agree with me that you were never able to fully exhaust those administrative remedies?
Again, there would never be a situation where you couldn't fully exhaust because of a situation like that. Because Ross v. Blake.
Let's take a
is
couple of
wrong.
different examples. Let's say an individual's case is thrown out because they filed the wrong form and are unable to get the correct forms. Is it not at all possible that there's a situation where an inmate goes to court, is rejected, and then is unable to comply with the rest of the administrative remedy process?
If the form is part of the administrative remedy process, then they would have to take a look at if it fell under one of the tests of Ross v. Blake.
Okay, thank you. No further questions.
According to Isha Anand, a Juris Doctor from UC Berkeley in April of 2021, quote, instead of preserving judicial resources, the PLRA has helped to preserve cruel and inhumane conditions inside America's prisons and jails. With the courthouse doors effectively closed, incarcerated people have few means to challenge or expose the dire conditions in which they are forced to live. Without access to the courts, not only are individual harms never redressed, but broader systematic reform remains out of reach. Dangerous living conditions, the psychological horrors of solitary confinement, beatings and rape, or disastrous health care, all are concealed from view and persist unchecked, end quote. That was from April of 2021. I'd like to read another one from 2018, 2 years after the Ross v. Blake decision. According to the Harvard Civil Liberty Review, they write in 2018, quote, the incidence of cruelty and lack of humane conditions lead one to wonder why prison conditions are exceptionally deplorable in the United States. It is no coincidence. The blame might lie with Congress and its efforts to limit prisoners' ability to claim better conditions. In 1996, Congress passed legislation making it harder for incarcerated individuals to bring claims. For many years, advocates have pointed to this piece of legislation, the PLRA, a tool stripping prisoners of their rights, end quote. I give you this information for a few reasons. One, to show you that there's a current problem. and 2, to show that it's a significant problem. I'm going to be going over a few things in today's speech, but mainly responding to the arguments brought up by the negative speaker. The first idea that he brought up was that they did not have access before the PLRA, and you can tag my response as not federal specific. Now today, we can understand that the PLRA as a federal law only applies in federal court. It's a federal specific law. But today they brought up evidence that did not specify anything on the federal level. There's actually way more prisoners in the state, and we're not affecting that by our claim. So they must show us that those people who didn't have access before the PLRA are actually on a federal level. The evidence that they talked about never talked about the PLRA, and it never talked about federal prisons or federal courts, what we're talking about today. So they must bring up evidence actually on the federal level and actually on the problem that we're dealing with for us to actually bring it in today's favor. The next idea that he brought up was that of Ross v. Blake, and how it had established essentially an exception, that of unavailable remedies. And I have a few responses. The first idea is that Ross v. Blake only recognized the exception as already existent. It did not establish a new exception. I went ahead and looked at the evidence, and it talked about how the case of Ross versus Blake in 2016 looked at the wording of the PLRA and found that there was one exception. They didn't establish a new exception in 2016, only recognized that it existed. Now they recognized this exception called unavailable remedies and said prisoners only have to exhaust available remedies. If it's unavailable, they don't have to do so. So let's see what the courts have done with that exception and if it's actually helped in the current system. Well, Isha Anand, the Juris Doctor that I quoted from my intro, talks about this issue a little bit. He says, quote, "In theory, the Supreme Court held that a grievance process is not available and therefore exhaustion is not required. In practice, courts have interpreted that exception so stringently as to make it meaningless," end quote. Although that exception in a technical and legal sense does exist, courts have interpreted it so narrowly as to make it meaningless. We do not see courts taking advantage of this exception, and as pressed in cross-examination, the negative team had no instances of this exception being used. We see the problem remains. But furthermore, we see further evidence from attorney Stephen B. Bright as he testified before Congress in 2008, and he writes about the available standard as well. He says, quote, "The argument that the PLRA need not be amended because courts can simply conclude that administrative remedies are not available within the meaning of the statute ignores reality. Grievance procedures may be available in a legal technical sense, but they are too complicated for most prisoners to comply, and they are strictly enforced to avoid justice rather than obtain it," end quote. So first of all, we understand that Ross v. Blake did not establish an exception. They only realized that there was one narrow exception, that of availability. We further see that courts have refused to recognize it and have interpreted it so stringently as to make it meaningless. We further see that the negative team has failed to bring any examples of this being a significant and helpful exception, so we see that the problem remains. We understand that though a remedy might be in a technical sense unavailable, that we see, or rather it is in a technical sense available, just nearly impossible for prisoners to comply with. That means that exception does not apply. I'd like to next talk about this idea of dismissed without prejudice. Dismissed without prejudice. And he essentially said that if a case is dismissed without prejudice, it can come back to the courts later after they've actually exhausted all of their administrative remedies. Now it's important to note that if a case is dismissed without prejudice, it is simply sent back into the same problem. The exhaustion provision, which has no accountability and hyper-technical requirements that a prisoner must fulfill. Even if it is dismissed without prejudice and not dismissed with prejudice, this person, before taking their case back to court a second time, has to exhaust all administrative remedies, thus sending them back to the original problem in the first place. According to David Fawkey, a JD from UC Berkeley, he writes in 2009, quote, "A basic structural problem with the exhaustion requirement is that prison officials themselves, the defendants in most lawsuits brought forth by prisoners, typically design the grievance system that prisoners must exhaust before filing suit. This creates obvious incentives for officials to design grievance systems with short deadlines, multiple steps, and numerous technical requirements. And unlike prior law, the PLRA imposes no requirements for grievance systems. The sky is the limit for the procedural complexity or difficulty of the exhaustion regime," end quote. He points out a few things. That these prisons have an incentive in making the grievance processes as difficult and nearly impossible. And secondly, he talks about, unlike prior law, the PLRA implemented no accountability and no requirements for the grievance system. That's what we provide today. We recognize that though exhaustion in a certain sense is important, and it must be there in a certain sense, it must be limited and it must have accountability and provide access to courts. Ian Head, a JD, a senior legal researcher at the Center for Constitutional Rights, speaks further on the grievance process in 2016, when he wrote, "This can take months. Imagine a prisoner who is in pain and in need of medical treatment, but ignored by prison staff. She must not only file her complaint with the same staff that is denying her the treatment, but wait for a refusal, appeal that decision, and only after a judgment on that appeal can she then file a legal case beyond prison walls. By that time, it may be too late for a court to do anything." End quote. There's no accountability for the current grievance processes. The Supreme Court has not established any more accountability, and as it remains in 2022, it is still a problem. Stephen B. Bright gives an account of a judge, a specific example in this case, and he writes this, quote, "A prisoner who had been beaten by other inmates maintained that he had failed to file a grievance within the 15 days required because he had been hospitalized. The magistrate judge recommended staying the case for 90 days to allow him to exhaust, as the amendment in the Prison Abuse Remedies Act would allow. These are not isolated examples, and they do not begin to tell how many cases are not brought, because it is clear that they will be dismissed for failure to comply with grievance procedures." End quote. We see even judges recommending that 90 days be stayed for grievance and that it must be allowed access to courts. JD Stephen Bright testified saying the exhaustion provision of the PLRA puts the potential civil rights defendants in charge of defining the procedural hurdles that a prisoner must clear in order to sue them. And he talks about the hyper-technical requirements. He goes on to talk about the lack of accountability. At the end of the day, we must reestablish accountability in the prison legal system and establish justice.
Great speech, Caleb. Just back to that, a couple of questions for you. My first one's just, how are you doing today?
I'm doing really well, Zach. How are you?
Doing pretty well, thanks for asking. Congratulations on getting to semifinals. My first question for you about your case is simply about the guy that you talked about being unconscious, and that's why he wasn't able to file his lawsuit. How long was he unconscious for?
He was unconscious for about 15 days.
Okay, and so the administrative remedy was 50 days or under.
Yeah, that's what the prison had created. They said there was that deadline in that instance. As he was hospitalized, he failed to complete it, and his case was forced to be thrown away.
Now, you brought up some evidence, more recent evidence, talking about how the PLRA is harmful. Could I see that evidence?
So both of them are tagged, this one 2021, this one 2018.
Okay. Now, was that actually talking about the exhaustion provision specifically?
It was talking about how the PLRA effectively closes the courthouse doors. The only section of the PLRA that actually deals with the ability to file in court and what the exhaustion looks like is the exhaustion provision.
Okay, interesting. You would also agree that the 3 strikes provision can prevent people from bringing cases in form of upright.
Yeah, I don't really know what the legal term, I guess, of that means, but the 3-strike rule is applicable. It says that if someone files 3 frivolous cases, then they have to pay an amount of money to continue filing, essentially.
Okay. So just to clarify, this evidence wasn't specifically about the exhaustion provision, but about the PLRA as a whole.
It was referencing the PLRA as a whole and how it closes the courthouse doors.
Now, you also brought up a part of evidence from Stephen Bright, correct? And that was testifying, he was testifying before Congress in 2008.
That is correct.
All right, and he said that prisons often make the administrative remedies too complicated for prisoners to complete.
There's a few pieces that I referenced by him, but one of them was saying that they create it so that it's nearly impossible for prisoners to be able to ever exhaust administrative remedies.
You can agree that in Ross v. Blake, the Supreme Court specifically addressed procedures that are too complicated or nearly impossible.
So all they said is that if a procedure, they went over the claim, and they said, and they found that if a procedure is unavailable, then the prisoner doesn't have to exhaust. But we see that as of 2021, the courts have interpreted that as to make it meaningless, and it hasn't applied actually in effect.
Okay. And Do you have any examples, or you brought up a couple of examples of unfair administrative remedies? Do you have some sort of an example from prisons specifically showing what the administrative remedies are?
I mean, we've read evidence talk about how they require certain forms. They have short 2 to 3 day deadlines. There have been cases that have been thrown away because the prisoner failed to do it in the ink color that the prison required, things like that.
Well, my time's up.
Thank you, Zach.
Zach and I believe in practical policy. That's what the PLRA is. Passed in 1996 in response to a huge growth of frivolous litigation, the PLRA was put in place to stop that frivolous litigation, to stop the overwhelming the court system, to ensure that actual justice was served. Under this year's resolution, the resolution states that the United States federal government should significantly reform its policies regarding convicted prisoners under federal jurisdiction. The one word I'd like to point out to you is significantly. The affirmative team has the burden to prove a significant form regarding convicted prisoners under federal jurisdiction in today's debate round. But unfortunately, because they haven't presented a harm and they can't fulfill that basic criteria of significance and a significant reform, that a negative ballot is warranted. So first, let's talk about the burden of proof that the affirmative team has. In cross-examination, I asked Nathaniel if he could agree they have the burden to prove a harm in the current system, to quantify that harm, and that their case actually solves that harm. He agreed they have to prove that there's a harm in the current system. But when I said that he had to quantify it, that was where we disagreed. There's no way for us to understand if there's any issue in the current system unless we have evidence of such issue. Now, in that same cross-ex, I asked for their advocacy, claiming that 90 days was going to be a sufficient amount of time, a sufficient reform to allow these inmates to actually exhaust the whole grievance process. He said they had advocacy from the American Bar Foundation. So when I read this piece of evidence from 2010, what it said was that with lawsuits stayed up to 90 days pending the administrative processing of the claim, after which a prisoner filed a grievance during the period of stay should be allowed to proceed the lawsuit of any federal procedural bar. What this piece of evidence said was it put out the idea of 90 days. It was written by the Bar Foundation, which means it could be a defense attorney. We don't know exactly who wrote this piece of evidence, but this is not advocacy for their plan. It's merely an idea of extending the PLRA from a 30-day exhaustion provision time limit to 90 days. So we don't have actual advocacy saying that there is a need for reform from maybe a judge or a justice. In cross-examination, I asked if equal protection under the law could also be a way in which we view justice, and they agreed. We understand that people, once there's something illegal has been done against them, they have a certain amount of time before they can file a claim. In that same breath, we give prisoners a certain amount of time in the current system to file their claim, so they aren't intimidating witnesses, and so they aren't bringing their case back to court again and again and again. So we see no studies of an actual harm. We see no claims by judges or justices of an actual harm in the current system, and because they must fulfill the burden of a significant harm and a significant reform, and we don't see that in the current system, that we can't pass their claim. Now I'd like to talk about my main significance point in this speech. 30 to 90 days. 30 to 90 days. They're passing the PARA, which is the PARA. And essentially what PARA does is several things. It completely removes the physical injury requirement. It changes the time limit for the exhaustion provision. But they're only passing one clause of PARA. They're only extending the time limit for 90 days. So for this to be a significant reform, we have to also see that 90 days is sufficient time for these prisoners to file lawsuits. But we understand that no change is going to actually be happening because there's an unsubstantiated harm, and 90 days, 60 more days is not going to solve the harm that they're claiming is present. Now I'd like to talk about my first inherency point, which is that incapacitation extends the exhaustion provision. Incapacitation extends the exhaustion provision. They claim that their case by courts has been proven to be unjust, essentially unconstitutional. But the Supreme Court case that we've actually heard about today, Ross versus Blake, demonstrates that if a person is incapacitated, just like that example in their 1AC of that one man who was, which was prior to Ross v. Blake, the courts held that incapacitation extends the exhaustion provision timeline. So if somebody's actually not able to fulfill all the grievance processes, they're incapacitated, they're not able to do so, maybe they're dealing with something else at that time, if they're able to prove that before a judge, that's actually able to be substantiated, then the time limit continues and it increases, and they have the amount of time that they need until they can actually file the claim effectively. My second inherency point is exceptions to the PLRA. Exceptions to the PLRA. One of the exceptions I'd like to talk about is if somebody is in imminent danger, then the PLRA three-strike provision does not apply to them. This is by John Powers, a JD, as well as Andrew Reeves, a JD. They quote, if a prisoner is under imminent danger of serious physical injury, the three-strikes rule does not apply under United States Code 1915, end quote. So what we understand is that it's up to the discretion of a judge to evaluate if somebody is in imminent danger. When they bring their claim before a court of law, the judge decides, is it going to be safe to return them, or should I listen to their claim immediately? Ultimately, judges have discretion to hear claims and to allow them to go through, regardless of the exhaustion provisions being fulfilled. My next inherency point is that a judge determines justice, and judges determine constitutionality. Mallory Johnson, 2011, says that, quote, even after it was enacted, opponents maintained that the provisions of the PLRA would be struck down as invalid by the courts. Courts did not strike down the provisions. 36, and in fact, courts have 36, that's citing the page number, and in fact, courts have repeatedly upheld the PLRA against unconstitutional attacks, end quote. If justice is truly being denied, if there's truly unconstitutional discrepancy between prisoners and citizens in the current system, why have our courts continued to hold that the PLRA is constitutional? That these prisoners have the ability and sufficient time to file their claims. They're not being denied habeas corpus. They have an opportunity for their claims to be heard. My last inherency point I'd like to talk about is alternatives to the PLRA. Alternatives to the PLRA. The PLRA is one form in which prisoners can file a lawsuit before a court of law. It's one route that they can go through. But there's other things besides the PLRA that prisoners can actually use to file their complaints if they're in danger. And one of those other forms is the FTCA. This is a piece of evidence from Michelle Seidel, who has her MBA as well as her JD. In 2020, she says that, quote, inmates can sue through the FTCA against a federal employee, not a private contractor with the government. Furthermore, the claim must be in line with state laws. Most FTCA lawsuits are about negligence, but some federal law enforcement officers can be sued for abuse as well, end quote. So even if the PLRA was found to be unjust in the current system, there's other routes of justice that these prisoners can use. So what do we understand at the end of this speech? We understand that the harm in the current system, which the affirmative team is claiming is present, has not been quantified. We haven't seen studies. We haven't seen evidence of a harm, which is a burden that they must fulfill. We also see that there are other routes of justice, that the exhaustion provision does not need to be extended because our courts have held that it's constitutional in the place where it is right now. We also understand they are not presenting a significant reform under the PARA. They're only extending a time limit, not even passing the full piece of legislation. It's for all these reasons we ask for a negative ballot.
Congratulate you on making semifinals. I do just have a few questions. Thank you so much. Can we agree that you have never contested in today's debate round is established by the Constitution and reaffirmed by the Supreme Court that prisoners have the right to access the court?
Absolutely.
All right. Now, can we agree that the piece of evidence from the American Bar Association did advocate for a 90-day time limit, correct?
It presented the idea of extending the PLRA time limit to 90 days, but it did not advocate specifically.
Right, but the piece recommended that that legislation be passed, that 90-day time limit be added, correct?
No, it presented the idea of possibly extending the time limit to 90 days, but we also don't have an author who wrote this piece of evidence. So it could be a defense attorney, somebody who wants their prisoner to have more time.
So is a defense attorney an illegitimate source if it was?
Well, not necessarily. However, we need to see advocacy
Sure.
that is unbiased, and also advocacy comes from the determined.
Wonderful. If you could hand me the piece of evidence from the American Bar Association, that would be wonderful. Now,
That was your piece. Would you like it back?
I would like it back, thank you. Now, you also talked about how we would want to affect, or might want to have advocacy from judges. You would agree in my last speech that I read evidence from a judge specifically saying that 90 days is the correct amount of time.
So that was specifically in regards to that one case in the example you brought up in your 1AC, but that was also prior to the decision of Ross v. Blake.
Okay, and we can further agree that that decision, or that judge said that didn't even begin to tell how many cases are not brought because it is clear that they will fail exhaustion provision, correct?
Okay, so you're talking about cases and opinions by judges all before the Supreme Court case of Ross v. Blake, which
Okay.
established the PLRA's
All right,
constitution.
did you respond to my evidence that the problem remains as of 2021 and the courthouse doors are still effectively closed?
Who said, or who were you quoting?
Juris Doctor from UC Berkeley.
So I didn't specifically respond to that piece of evidence. My partner will be addressing your last
All right.
speech. This was just furthering the argumentation.
Sure, and we can agree that as of 2021 in our 1AC, we talked about how thousands of cases are dismissed because of failure to exhaust.
So I didn't, again, my partner will be addressing your last speech. I
Wonderful.
didn't respond to your evidence in this
All right,
speech.
and we can agree that Ross v. Blake overall recognized only one exception, correct? That if it's unavailable, they don't have to pursue remedies, correct?
Exactly, which is the main contention of why you believe there needs to be extension of time.
And did you respond to either piece of evidence that talked about how prisons make it available is just nearly impossible, as well as the fact that the courts have interpreted it so as to make it meaningless? Did you respond to either of those points?
Sorry, I don't believe I understand your question.
Okay, we'll move on. My partner will address it better. You talked about the 3 strikes provision. We can agree that we're not talking about the 3 strikes provision and we don't change that provision in the least, correct?
What that piece of evidence demonstrated is that it's up to a judge, their own discretion, if someone is in imminent danger. They're actually hearing the case and they can allow it to pass
With
through.
a totally separate provision, not the exhaustion provision. We can agree that the judge is still bound by the exhaustion provision, correct?
No, it's up to the judges. They have discretion.
It
even
said that for
with
the
exhaustion.
3 strike provision, correct?
With hearing a claim in regarding whether it's frivolous or not frivolous.
All right, could I get that piece of evidence, please?
Sure.
Now, what
Which piece of evidence?
That one on the 3 strikes provision.
Sure.
Thank you. You need to try to find 5 minutes. Oh, it's not a speech. No, it's
We will be beginning prep time at 50 seconds. Let's go ahead and get started. The most basic job of the affirmative team in any team policy debate round is to uphold their burden of proof. Their burden to prove that their plan will cause a significant net benefit over the current system. Unfortunately, in today's round, the affirmative team has not upheld that burden of proof. They presented a lot of evidence that seems convincing at first glance. However, when we really go in depth with the evidence, when we really go in depth with the court cases, they side with the negative team. What I'm going to be doing in the first rebuttal of today's round is responding to the affirmative team's 2AC and showing why my arguments, especially my arguments surrounding Ross v. Blake, still stand in today's round. Now, I'd like to begin by talking a little bit about whether the affirmative team has proven that people will have access to the courts after their plan is passed. Now, they really only had one response to this argument, and it was simply that our evidence isn't federally specific. So I would again just like to remind you that they haven't actually proven that people will have access to the courts after their plan is passed with this evidence. Now, their one response that our evidence isn't federally specific also doesn't apply for one simple reason. The PLRA isn't federally specific either. You can write it down as PLRA, not federal specific. PLRA, not federal specific. This card of evidence comes from Human Rights Watch, June 15th, 2009, excuse me. It says, quote, the PLRA governs lawsuits brought in the federal courts of the United States whether those lawsuits involve federal, state, or local facilities, unquote. So simply saying that our evidence is talking about is not specific to federal prisoners, but could include federal and state prisoners, is not any response, because we're talking about a statute that is not specific to federal prisoners. Now, the affirmative team has gotten around this to uphold the resolution by specifying that their mandate is to federal prisoners, but my argument wasn't about their mandate. It was about how the PLRA was, how the world was before the PLRA was passed and after the PLRA was passed. So again, my evidence still stands in today's round. Before the PLRA was passed, prisoners did not have access to courts. They have not been able to prove that their plan will change that. I'd like to address the arguments surrounding Ross v. Blake and show specifically why the Supreme Court decision fixed the problem. Now, the affirmative team had essentially two responses. They talked about how this wasn't a new exception. Essentially, the Supreme Court just interpreted this exception, and I have one response. Interpreted exception. Interpreted exception. Yes, the Supreme Court merely said that there was an exception in the bill already. However, that's just how the Supreme Court works. The Supreme Court doesn't write any new legislation. If we look to one of the most notable things that the Supreme Court has done in recent memory, they interpreted a right to abortion into the Constitution. Now, they didn't create a new part of the Constitution. They said that that right was always in there, but they didn't. But it essentially created a new right. That's just what the Constitution does, and so simply saying that they interpreted the law, that's not any response at all. Now, I'd like to respond to their second main argument, which was that these remedies are technically available, but not actually available. I have one main response, and then I'm going to have a couple of subpoints. My main response is addressed by Ross v. Blake. Addressed by Ross v. Blake. The fact that, or claiming that these remedies are technically available was actually addressed in Ross v. Blake by their three-pronged test for whether these remedies are available. I'd like to talk about those tests now, those three-pronged tests. The first you can write down as dead end. Dead end. All of this evidence is going to come from the Supreme Court decision, and it says, quote, it's coming from the Supreme Court decision of Ross v. Blake. It says, quote, as Booth made clear, an administrative procedure is unavailable when, despite what regulations or guidance materials may promise, it operates as a simple dead end, unquote. The second exception you can write down as confusing. Confusing. Again, from the decision, it says, quote, an administrative scheme might be so opaque that it becomes, practically speaking, incapable of use. In this situation, some mechanism exists to provide relief, but no ordinary prisoner can discern or navigate it. As the Solicitor General put the point, when rules are so confusing that no reasonable prisoner can use them, then they're no longer available, unquote. Again, if the things are too confusing, then they can't use them. The third one you can write down is being thwarted. Being thwarted. This directly responds to the card of evidence the affirmative team read, responding to Ross v. Blake. The Supreme Court directly addressed those kind of cases. Ultimately, the affirmative team has not upheld their burden of proof that I asked for a negative ballot. Thank you.
Nelson Mandela once said, you never truly know a society until you spend time in its prisons. A society should not be judged by how it treats its highest, but by how it treats its lowest. And unfortunately, we treat our lowest, those who are incarcerated in our federal prisons, in an abysmal fashion. We'll get to this later on in the speech as I give you a voting issue, but the first thing I want to do is answer the questions and the concerns brought by the negative team. And I have a couple of main arguments and ideas that fall into two main categories, questions and concerns, and I'll be addressing all of these. First, under the issue of significance. They've asked us to prove a significant harm, and so I'd like to continue to do so. Not only have we shown you that thousands of cases are dismissed, that the PLRA is the biggest obstacle to constitutional rights, but it's further explained by John Boston of the Legal Aid Society in 2021 that more prisoners lose their cases for failure to exhaust administrative remedies than from any other part of the PLRA. From recent evidence just last year, we see that the PLRA, the exhaustion requirement specifically, is still a problem and is the major problem. But then we're looking more at this idea of significance, the idea of a significant advantage. What does our policy actually affect? Well, I'm here to tell you that our policy doesn't only affect those who have been abused, it also affects the entire system of accountability. You can write this down as entire system of accountability. According to Professor of Law Margot Schlanger, she wrote in 2008, when federal courthouses are barred to constitutionally meritorious cases, the resulting harm is not merely to the affected prisoners, but to our entire system of accountability that ensures that government officials comply with constitutional mandates. The erection of hurdles to accountability should not be seen as reducing a burden for correctional administrators. It should be recognized as weakening the rule of law. The PLRA must be amended. That is the significance of our policy. And furthermore on this argument, I've got one more response. That to prove significance, it's not just about numbers. Not only have I shown you numbers of thousands of cases being dismissed, but the significance of this policy is not just about individual prisoners, it's about the entire system of accountability. Second, we look at the idea of advocacy. Now, Haley responded to one of our advocates, but we have many more. Not only does the American Bar Association advocate for our policy, but also the Philadelphia Bar Association, also attorneys and professors of law, and specifically we see even a magistrate judge recommends 90 days. We have advocates for our policy. This third brings me into the idea of exceptions, and this is the idea of Ross versus Blake. The first response here is only one exception exists. As agreed to in cross-examination, the only exception established under Ross versus Blake was unavailable, or unavailability. And Caleb disproved this by reading the evidence that said it is so rarely used, which never went responded to. It is rarely used in the system, and as such, this exception is practically meaningless. But the third response here is that exceptions prove the harm. Exceptions prove the harm. From the facts of the matter that there needs to be an exception, it shows that the law itself is broken, and as such, that law must be changed. And the fourth response here is that there were no numbers on these exceptions. I asked about this in cross-examination, and Zach and Haley have failed to bring any evidence of any individuals or even numbers on people who have used the exceptions to have their cases heard. Fourth, we look at the issue of constitutionality, and I'd actually like to shift the burden on this argument. If they want to show us that the current system is constitutional, they need to read not just a quote, but the actual case that proves the exhaustion requirement specifically is constitutional. Until they do that, you cannot assume that argument is true. And finally, we get to the issue of whether people will file or not. A couple of main responses. First, thousands of people are denied because of the exhaustion provision. Those thousands of people would be allowed to file. Second, you look at the advocacy referenced under, I believe it was Advantage 1 in our policy, that it would ensure meaningful access to the courts to vindicate their constitutional rights. That's what our policy does. And the third thing is that the evidence Zach brought up is not on the federal system. It was before the PLRA, and as such, it doesn't apply in today's debate room. Next, we move on to the technical concerns. First, Haley talked about time limits, and specifically that we were extending the time limit. That's not what we're doing. If you look back to the 1AC, there are no standards in place currently. We provide accountability to the system by putting a time limit in place. Second, we look at the three strikes rule. This has nothing to do with our policy. The three strikes rule is a completely separate provision and has nothing to do with this debate round. And third, we look at things other than the PLRA. If you reference back to the 1AC, you will see that the exhaustion requirement applies to all types of prisoner lawsuits. And I read that card in the beginning of my first speech. Finally, this brings me to the moral imperative in today's debate round, that of the voting issue in this round. Nelson Mandela had it right when he said that a society should be judged by how we treat our lowest. Right now, our lowest are being beaten, mocked, abused, tortured, and their constitutional rights are being violated. They have no legal recourse by which they can remedy these situations, but our policy would. As a result of passing PAR, you restore constitutional rights to federal inmates. Thank you.
Is the PLRA constitutional? Is the PLRA a practical policy? And would extending the time limit in the exhaustion provision from 30 to 90 days actually help these prisoners fulfill the grievance process? The answer is that the PLRA is constitutional, and 90 days is not a significant reform. The issue that the affirmative team has continued to talk about throughout this whole debate round is that the grievance process is completely unjust. That the BOP and these federal prisons are requiring inmates to use certain colored ink to fulfill the grievance requirements, and that's unjust. However, their answer to that injustice is to extend the time limit for the exhaustion provision to 90 days, not to actually change the grievance process at the prisons themselves. It's because there is no harm in the current system, And furthermore, because the affirmative team does not present a significant reform, that a negative ballot is warranted. I'll have 3 voting issues in this last negative speech. The first one is constitutional. Constitutional. Now, Nathaniel in his last speech said that we have to prove that the courts have said with their actual wording, we have to read the court cases themselves, that the PLRA is constitutional. Now, I'd like to remind you that unconstitutionality was something advocated by the affirmative team themselves. They're the ones who said that the PLRA was unconstitutional. However, the only Supreme Court cases that we've seen in this debate round say that the PLRA is constitutional. I'll read you one right now from Mallory Yance. When she's talking about the Supreme Court cases and district court cases, she says, courts have repeatedly upheld the PLRA as unconstitutional, against unconstitutional attacks, end quote. We understand that Ross versus Blake also upheld the PLRA as constitutional. And inside Ross versus Blake, they outlined an exception, the unavailability exception, which Nathaniel said is that the only exception in Ross versus Blake, the unavailability exception, is not used, and so thus it's ineffective. But evidence of it not being used often is not evidence that the exception is ineffective, but rather that it's not really needed. They haven't been able to quantify their harm. And so if they're trying to say that this exception is not effective, they have to show us how many cases have still not been able to go through the PLRA. My second voting issue is just. They've completely dropped my argument, my fourth inherency point, that of the FTCA being another way in which prisoners can go to court. They completely didn't respond to it, so I ask that Caleb in his last speech not respond to it, since we won't have an opportunity to further discuss it. But the FTCA is just one example of another route in which prisoners can take to go to the courts. So if the grievance process is holding them back from justice, there's other routes to justice. My last voting issue is the burden of proof. The burden of proof. They have the burden to prove a significant reform. They agree that they have a burden of proof in this debate round, but have failed to provide us with statistics. They failed to provide us a connection between a 90-day time extension from 60 days, 30 to 90, and an actual reform and significant help for these prisoners. The issues with the grievance process, not the time limit. There's not going to be any advantage to passing their plan. Now, they also talked about advocacy, and Nathaniel referenced many different groups. However, I'd like to point out that he didn't bring up any evidence for the other advocacy that they have. What we understand is that the only piece of evidence Zach and I have been presented with in this debate round, advocacy for their plan, is from the American Bar Association, no title, no author. It could be from any local lawyer, probably a defense attorney, saying 90 days is an idea. Not even saying that 90 days is something that should be passed, that it should be reformed to the PLRA, but simply that it's an idea of a reform. We understand that the affirmative team has good intentions, but they've limited the PARA, a reform of the PLRA, so much to where it's not actually going to help these prisoners in any way, shape, or form. The current system is effective. It was passed in response to extensive frivolous litigation. And by extending the time limit and not actually changing the grievance process, we're not doing anything significant for these prisoners. But furthermore, we also understand that justice is still being served because they have other methods in which they can reach the courts. And it's up to the judges ultimately to decide whether or not to hear their claim. If they bring a claim and they're in imminent danger, regardless of whether or not they fulfill the exhaustion provision, a judge can still choose to hear that claim. So I'd like to ask you a question at the end of this debate round. Is the PLRA constitutional? Yes, we see through court cases it is. Is the PLRA just? Yes, we understand it is because there's other alternatives. And has the burden of proof been fulfilled? No, it has not.
Starting from 3 minutes and 30 seconds.
The current system is unjust and has no accountability. That's the problem in today's system. I'm going to give you 3 main voting issues and ask you to affirm the resolution today. The first voting issue you can tag is right to access the court. This has gone unresponded to by the negative team in today's entire debate round. We understand that as established by the Constitution and reaffirmed by the Supreme Court under Bounds versus Smith, that prisoners have the fundamental right to access the court. Reiterating what we read in our 1AC, according to J.D. Melissa Benaroff in 2021, quote, one of the most important federal rights recognized by the courts was a prisoner's fundamental right to access the courts in the first place. So we understand they have the fundamental right to access the court. So the constitutional issue comes down to that. Is the right of access being blocked? And in 2015, the University of Baltimore Law Review noted that, quote, the single biggest obstacle in the way of vindicating constitutional rights is the Prison Litigation Reform Act, specifically the exhaustion requirement. Failure to adhere to even the slightest procedural requirement is sufficient to warrant the dismissal, regardless of the merits of the underlying claim, end quote. What we can understand is that judges do not have the option to change. Judges do not have the option to overrule their PLRA. We'll talk about that in a bit, but we understand that they have the right to access the court. The second idea is voting issue 2, access denied. Access denied. We understand there's a constitutional violation. I just read you evidence that the exhaustion provision is seen as the biggest way in blocking the vindicating constitutional rights. Furthermore, I read evidence in my second affirmative constructed that went unresponded to, that the PLRA effectively closes the courthouse doors, and that was as of 2021. We see a current problem. Next, they brought up a few ideas of the courts. The first was that of Ross versus Blake. They claimed that Ross versus Blake affirmed the constitutionality of the PLRA, but this is absolutely not the case and is actually completely misclaimed by the negative team. Ross v. Blake was only looking at whether there are exceptions in the exhaustion requirements. They were not looking at its constitutionality. And I would remind you that they found one exception. According to Celeste Valencia in 2017, she reports, according to the American Academy of Law, she reports, the court's reasoning emphasized that legislation unambiguously allows only one excuse to fail to exhaust administrative remedies, when administrative remedy is not available for use, end quote. And I would remind you of our 2 responses that have continued to go unresponded to. As of 2021, courts have refused to apply this standard and have interpreted it so stringently, quoting the evidence, as to make it meaningless. Furthermore, we understand that prisoners, because they are held, or rather prisons, they are held to the standard to make these grievance processes available. They, as our evidence said, make these prison grievance processes available in a legal and technical sense. They just make them so difficult that no reasonable prisoner can be expected to be able to go through it. So we understand that Ross v. Blake only was looking at exceptions, and we see well after that those exceptions have failed to work and that the courthouse doors are still closed. They brought up one other constitutionality argument, and it said in general, and from 2011, that courts have upheld its constitutionality. Nathaniel and I asked to see if this is the case. Could we see one case that upheld its constitutionality? Not just its constitutionality, but the exhaustion requirement specifically. They were unable to give us a single case. If that evidence is true in saying that there are plenty of court cases that have upheld its constitutionality, the negative team should be able to point us to even a singular case, which they have failed to do in today's debate round. The next idea that she brought up was that of the FTCA and that they have other options around the PLRA. And she asked me not to respond to this in my speech, and so I won't really respond to it. I'll talk about what my partner said in his 1AR, that it is applied to all prisoner lawsuits. The PLRA applies aggressively and excessively to every single prisoner lawsuit, and we read evidence early on in this regard. The FTCA falls under every prisoner lawsuit. The next idea is that the 90 days is the correct advocacy. They said that we provided them only one piece of advocacy, which we actually handed them a full page of advocacy, which gave them a few things. They chose to look at one of those pieces on the page, and that was the American Bar Association, and they said that it did not advocate for it. I'd like to read the evidence. According to the American Bar Association, quote, a prisoner who files a lawsuit with respect to prison conditions but has not exhausted administrative remedies at the time the lawsuit is filed should be permitted to pursue the claim through the grievance process with the lawsuit stayed up for 90 days pending the administrative processing of the claim, after which a prisoner who filed a grievance during the period of stay should be allowed to proceed with the suit without any procedural bar, end quote. The American Bar Association was advocating for our plan and saying this should be implemented. Furthermore, I'd like to finally reread how we restore accountability. Stephen B. Wright testified saying the Prison Abuse Remedies Act would correct the problem by allowing federal courts to stay proceedings up to 90 days to permit prisoners to exhaust administrative remedies. Prison officials would have an opportunity to resolve such complaints, but they would not be able to dodge accountability, end quote. We've given you judges, attorneys, and every other kind of evidence to support our plan. We ask that you uphold the Constitution and the rights of prisoners today. Thank you.